Good morning. Thank you so much for coming on board for day 2 of SASCon. How many of you were in yesterday? Just lift your hands. Oh my God, amazing. Thank you, guys. This is really nice. We'll start off today, and the first session we're going to start off is, as you see, the boring legal of India-US corridor. This particular session is a really personal subject of mine because when I start up, my latest startup, Event HQ, the incorporation process is still going on, I'd say, and it's been a year, and still struggling with it. There's been a lot of changes that came in this 1 year, which we continue to face as a team. But then without folks like inventors, it wouldn't have been possible to navigate through all of it. It initially started with one way, and then there was a new type of incorporation that came into place. So a lot of things. And to highlight all of that, we have Ashitha today. She's partner at Inventus, and she's going to be walking us through what it means to start up and what these regulations are going to mean to us. So if I see a lot of founders in the crowd, and if you have any questions, Ashitha is the person to speak to. Thank you so much for coming on board, Ashitha.
Thanks, Chameli. Thanks so much for that wonderful introduction, and good morning, everybody. Thank you so much for coming here today and taking a break from the networking that's happening outside, which is, I understand, a lot more interesting than listening to some boring legal topics that we're going to talk about today. But I hope that by the end of this session, other than keeping you awake for the rest of the session, I've also scared you enough to understand that it's really, really important to get your legal in order. Because if you don't, some of the things we'll talk about today hopefully will never happen to you, but that's what we're here to prevent. So let me start with a little bit of introduction about myself. My name is Ashitha Bhagwan, and I'm the managing partner of Inventus Law Technology Partners. We're a cross-border law firm. We're headquartered in San Francisco in the United States. We have offices in San Jose, in Delhi, and in Bangalore. And our primary focus is working with startups in the cross-border space, specifically in the India-US corridor. And this is primarily because we do have experience working in the US and in India. So we have a team full of lawyers who are trained to understand what the RBI laws look like, what the ODI regulations look like, and also what the SEC looks like and how that impacts you as Indian founders trying to set up global companies. We work with startups through their entire life cycle, so starting from the pre-incorporation stages, when you just have an idea, you are two guys, and you have this phenomenal experience behind you, or you have a really great idea that you want to bring to the fore, all the way up to the post-exit stages, where the startup grows, you raise a few rounds of funding, and then you go on and potentially get acquired, or you have some sort of an exit strategy in place. We end up working with companies through their entire life cycle. And based on our experience working with these companies, we've seen a number of issues that we encounter on a regular basis. While each startup is different and each company has its own set of issues, some things that remain common across the table are what we're going to discuss today. Right? So the way I've done this before, which seems to really work with a lot of the audience, is to list out or sort of talk about the high-level issues that startups need to look at and startups should be aware of before they even get started or even in the process of getting started. So what we've done here is spoken about or addressed some of the top 10 legal issues that startups should be aware of. And I'll go through each one of these in detail, but please feel free to stop me in between if you have specific questions or if you have any inputs that you have experienced that might be contrary to it or that might add to whatever we are talking about today. Yes? Okay, before I go into this, quick show of hands. How many of you here have global products that you're looking at, which is not just focused on the India market, but that's focused on a larger market? Okay, so that's pretty much most of the room here. So what I'll do is I'll talk about some of these in a little bit of greater detail, just to make sure that for the people who are also looking at a global product beyond just India, it might be more relevant to you. So one of the most important things, as many of you know, and Chameli actually did mention in her introductory speech today, is the fact that choosing the right global structure for your company, especially if you are building a global product, is of utmost importance, right? It's the first step that you have to take when you're setting up a company. It's really the first formal legal structure that you are creating, and it goes beyond just, hiring somebody down the street to set up an LLP for you or to set up a one-person company for you because, hey, it's easy, but I still have an entity in place, so it'll allow me to sign contracts, which is what a lot of us end up thinking because, yes, it's the lowest hanging fruit. But what ends up happening when you are looking at a global product is that that's only going to take you so far, right? And because you have this crutch, which is, okay, I have an OPC that has been set up, or I do have this, me and my uncle have a partnership, and, I can just use that, it's already in existence, you don't really look at what happens beyond that, right? And why this is so relevant is because recently, and when I say recently, I mean almost 2 years ago, in fact, exactly 2 years ago, right? 22nd August 2022 was when the RBI came up with new regulations which govern the overseas direct investment and overseas portfolio investments that are made by Indian residents. Now, what this means for us is that as Indian residents, if we are trying to acquire shares in a non-India company, which is what we would all do as founders, right? We own equity in non-India companies, and that entity usually has a step-down subsidiary here. There are very specific rules and regulations that have been laid out that apply to all of us as Indian residents that we are required to follow. So essentially, if we don't follow it, then we are not in compliance with the laws as of today. It doesn't matter that the company is outside of India and we are sitting here. It's very relevant to us because we are sitting here, because we are residents here, right? And what we normally see with this global structure that we have to create under the new regulations looks exactly like what you see on the screen. So we have a US parent company, and we have an India subsidiary. Now, US can also be replaced with other countries, but for the purposes of today's presentation, we'll talk about US. The US parent company is where all of the value is, right? So that's where you have the founders who will own shares, you have the investors who you will raise financing from, and you will give them shares in the US company, and then you will also have the ESOP pool. Now, the biggest challenge for those of you who've been around for a while, and specifically pre-2022, you know that this structure was similar. The part about US entity, India subsidiary, all of this was similar. But what was different then is that a lot of founders got shares through gifting and other methods, right? Now that has specifically been carved out, or that is specifically, now the ODI regulations have given us a specific way to do that, which is to do it via the LLP. So the most popular way that we see for global structures right now is that founders form an LLP in India, and the LLP buys shares in the US company, and the US company then sets up a subsidiary in India, right? And this subsidiary is usually a wholly owned or a 99.99% subsidiary. 1 or 2 shares are held by somebody else here, and this is the structure that we are usually looking at, right? So keep in mind that anything other than this is probably not in compliance with the law. Right? If you have a global structure, if you want to raise funding from global investors, if you want to sell to customers who are not just in India, who are everywhere else, you need to have an entity outside of India. And if you do, then you have to follow a structure that will allow you to grow and scale instead of having to look over your shoulder each time and say, hey, is this going to work, or are they going to come in as an investor, or are they going to ask us to restructure? This is a tried and tested method. It's worked for several years and hopefully will continue to work, so please keep that in mind. Now, the next issue that we often see, which I did allude to earlier, is about choosing the wrong entity form. So what I mean by entity form is, should you be an OPC? Should you be an LLP? Should you be a private limited if you're looking at India? If you're looking at the US, then should you be an LLC, which is another entity form, which a lot of founders come back and ask us, why can't we be an LLC? It's really easy to form. And I already have my relative who's there, and he can help me form the LLC. Should I be an LLP, which is also a structure there? Or should I be a corporation? So the answer to this is very simple, right? You can look at all of these questions that we have, and you can do a lot of analysis about it, but it's very straightforward. you should be a Delaware C corporation, and you should have a private limited in India. Those are the only two things that you will need. The LLP structure which has come in, which I told you about in the previous slide, is only to hold the founder's shares, is not to run the company in India. So when you are setting up this global structure, keep in mind that the three entity forms that you will need to use are the corporation, the Delaware C corporation. You can't be an S corporation, but a C corporation. You will have an LLP that will hold your founder's shares, and then you will have a private limited that will be set up in India to run operations here. And yes?
In fact, I'm just going through this whole process now. So is that service agreement actually required, or because you're doing a wholly subsidiary India Private Limited, what we heard is the service agreement is not required, so you could just have the funds from there to here.
How will you send the funds from there to here? That's exactly the point, right?
So we'll still have the India Private Limited, right?
Right, but how will you send it there? See, please keep in mind that every time money moves borders, and this is just general of everywhere, right? Anytime money moves borders, there has to be a way to account for it,
Okay.
right? So what the services agreement allows you to do is it sets up a cost plus arrangement between the entities. So essentially, the India entity will raise an invoice and say that these are the services that I've provided, and as a consequence, you pay me for it. And the US entity is going to say, all right, here's the money for it, and I get to benefit from your services, from the IP you've created, for everything else that the India entity has done. So the services agreement actually allows you to move money between US and India. So the question about not having a services agreement doesn't arise in most of our situations, right? If we're talking about SaaS companies, that have large development teams here, that raise money in the US, that, sell to US or global customers, then you will need to have a services agreement in place.
Okay. And one last point. There's one thing that is missing here is about, how do the investors in India can also invest?
Yes. So that's a very interesting question, and in fact, at every session that I've done, this always comes up, right? Even if it's not something that we've initially spoken about. I'm happy to talk about it in short, because that itself can go into an entire hour-long conversation. But for investors who cannot invest in the US in this structure, either because they're an AIF, or they are regulated here, or they have to go through the ODI process and they're unable to, there is a way that we have done pretty successfully over the last decade or so, which allows them to invest in the subsidiary in India, so the India Private Limited company, and get rights as if they invested in the US company. They also get a put option for exit proceeds that they can realize in India instead of having to go to the US.
Okay, thank you.
So that's the short of it, but yes, there are different layers, flavors, and complications that can arise from it, but it is possible to do it. Okay? All right, so the entity form, again, is very critical. Short answer is Delaware Corporation, Private Limited, LLP would be your go-to answers to it. Now, we have a little chart here that just talks about the different kinds of entities that we have. Now, in India, since we're talking about specifically, the OPC was what we discussed. And then we have the limited liability partnership and the registered partnership. The difference between the LLP and the registered partnership, in case you're wondering, is that the LLP actually gives you limited liability. So you are liable to the extent of your contribution to the company, versus the registered partnership is unlimited, right? So our preference is always to go with limited liability, because you want the entity to form a shield around you and you don't want it to go after your personal assets. And that's what the LLP will allow you to do. And then, of course, we have the private limited, which is what you need to run operations. And especially in that shadow structure that your colleague just brought up, we will need to have a private limited, because that will allow you to issue 2 classes of shares and allow you to do a bunch of other things with it. Yes? Okay. Now, one additional pretty important aspect which a lot of our founders end up ignoring, especially in the initial stages, when you don't have a product or an investor really knocking in the door, is ignoring your prior employment commitments. And what I mean by this is many of our founders don't necessarily do this right from day one, right? In the sense that they're probably moonlighting, they're working somewhere else, they're thinking about the idea, and they are trying to work on it in the meantime, while they also hold down a full-time job. Now, the issue with this is that many times in employment contracts, there are clauses that ensure that anything that you're working on, either on company time or using company property or during the time that you've been employed with the company, belongs to the company, right? Assuming, of course, it's relating to the business. And relating to the business is very broad, right? Unless it's a very narrow definition that has been specifically laid out there, it becomes very important for you, especially when you're starting up something with other people, not just yourself, is to look at the employment agreements that they have had and you have had with your prior employers to see if there is any sort of conflict or to see if there's any probability that your former employer might come after you and claim a stake in the startup that you're thinking of starting, right? I'm not just talking about the non-competes and the non-solicits, right? That exists anyway. But considering that a lot of the startups that we have, especially in this room, are focused on software and tech as the core asset, and if this is something that you've done before, and you've done before with another entity which you have been employed with full-time, then really, really important to make sure that there's nothing from that entity you're bringing over to this new entity, right? Now, what you have learned and the lessons you have taken from it, nobody can come after you for it. But the issue becomes if you copy their code, for example, right? That's the most easiest way to spot it. But if not, if you have been working on company property, so let's say you've been using the same laptop that your company has provided you to start building a platform for your startup that you're looking at, and what you do for your startup is somewhat similar to what you did previously, then it's a problem. Similarly, if you've been working during office hours, right, you say, okay, hey, I have downtime, there's nothing to do this afternoon, my deliverables are already out, I might as well work on my startup, that's probably not going to fly either, right? So please be really, really careful when you're thinking about it, because you want to make sure that there's nothing in your employment agreements, and really there's nothing in the conduct that you have before you started your company that might become a problem for you after you've put together your startup. Okay. All right. The next big thing that is very important to everybody in this room specifically is intellectual property strategy. Now, IP is a very large, all-encompassing word, and we can't go into very specific details about whether it's patents or trademarks or copyrights or what needs to happen, but please keep in mind that as companies that are really heavy on the tech, you really need to spend some time thinking about what your IP strategy is going to be. Are you going to protect it and register it? Are you going to rely on the fact that copyright law says that the artist or the person who creates it owns it and not do anything else about it? Are you going to file a patent? If you're going to file a patent, is it going to be processed? What kind of patent are you going to file? Are you going to file a patent in India and not in other jurisdictions? So you really have to spend some time thinking about what your IP strategy is, and this is beyond just the registrations, right? So there are some things here that would be very relevant to you, at least at the initial stages. So even if you said that, hey, I'm quite a while away from filing a patent because we still don't have everything in order and we're looking into it, you should realize that every person who's working on your IP, and when I say IP, it could be your designers, it could be your developers, it could be your engineers that you're working with, your friends who are helping you, put together the initial landing page, whatever it is that you're doing, all of that IP that they are creating has to belong to the company. And that's where we have invention assignments that come in, right? So these people may or may not be working full-time for you, but if they are creating something by virtue of your request and you are paying them for it or you are compensating them for it in some way, then you need to make sure that whatever they have created belongs to the company and not to them individually, right? So let's say you hire an intern, right? An intern is somebody you may pay, you may not pay, you may pay a lot, they may come in at hours that are convenient to them, whatever it is. But if they did something for you, right? If they helped put together, one small part of your website, for example, You want to make sure that that actually belongs to the company and the intern doesn't walk away with it. Because if they don't sign a piece of paper which says that everything that they have created belongs to the startup, then there's a very good chance that they do walk away from that. So please make sure that you do have invention assignment agreements in place. Now, these are usually rolled into your employment agreements. They can come as a separate CIAA or a PIAA. But whatever it is, you need to have the invention assignments in place. The next thing with respect to intellectual property strategy is your terms of service, privacy policy, and things that you need to put up on your website so that a customer who's coming to it understands the terms on which you are interacting with them. So if you have, it's really easy to copy and paste a TOS from somebody else's website, but I would never recommend that because you don't know what data privacy laws are applicable to you. You don't know if there are specific aspects. I'll give you an example. In California, there's something called the COPA, which says that, if your product is targeted to children under 10, 12 years old, then there are specific requirements that you need to follow in order to run a website and run an app that allows them to access it, right? That's not necessarily the rule in Europe, and that may not necessarily be the rule in India. So if you have a global product, then it's really important to keep in mind that you have to figure out what your target audience is, what jurisdiction your customers are coming from and are accessing your product, and what laws are applicable in that specific jurisdiction, right? This also applies to data that you collect from them. And when I say data you collect, it's personally identifiable information, their name, their email address, whatever else you need to get from them in order to either give them a subscription or sometimes even to view certain parts of your product or your platform, you do get them to sign up, right? So what happens to that data? How are you treating it? How are you storing it? Do you archive it after a while? Do you discard it after a while, right? All of these things have to be discussed and have to be taken into consideration before you go out and present to customers and potentially, have some claim at a later stage. So please keep in mind that all of this goes under the broad heading of intellectual property, and important to think about it before you go forward with it. Okay. All right, so licenses and permits. Again, this is very, very specific to the place where potentially you have your office and the industry that you're in. So again, if you're looking at a global product, then let's say that you set up in Delaware because, yes, I heard that that's the best place to set up, great. You hire a couple of people who are in the Bay Area, and now you want to hire an office for them, right? So you sign up with WeWork and you say, okay, you can go in twice a week and do this, right? At that point of time, California requires you to get a license to operate in that state. So it's called a registration or a qualification to do business. Because US, unlike India, as you know, is very state-specific, right? The laws are very state-specific. So if you have registered as a company, as a corporation in the state of Delaware, that doesn't automatically let you operate in other states. What you are required to do then is if you do set up an office in California, like I was discussing, then you have to qualify to do business in the state of California. So you have to get a license to do that. You have to get a registration to do that. It's very straightforward, but you have to do that. Same thing with other states. But the one thing about the different states in the US is that the same law may not be applicable everywhere, right? So if I were to open an office or if I were to have a warehouse, maybe all states would require me to have a license. But if I were to just have an employee there and they are sort of working remote, then maybe I don't need to have that, right? So it's really state specific. Just make sure that you check on that before you go through with it. Similarly, in India as well, you might need the shops and establishment license. You might need industry-specific licenses based on what you're doing. If you're in a software park, then there's a license that you get there. So please make sure that you keep your eyes and ears open, and then at least check in with your advisors to see, what is it that I need to get, or what direction should I be looking at? So I'm thinking about it and then making sure that you preempt it instead of having to fix it later on. Okay. All right, this is one of the biggest things that we see a lot of issues with, especially when relationships go sour, or if the team is not on the same page with respect to motivation or to stay continuing to provide services to the business. What vesting does is it's an excellent mechanism to motivate your employees or motivate your team. I won't say employees because this applies to founders a lot more than it does to the team, or as much as it does to the team. Allows you to keep them motivated and at the same time penalize them if they were to leave at a time that you hadn't, potentially agreed to. So the way vesting works, or what we mostly do is reverse vesting, although we call it vesting, is that you issue the stock on day one, and then the company has a right of repurchase that lapses over a predetermined period of time, right? So if I were to be awarded, say, 100 shares of Google because I'm going to start working for them, they have a repurchase right over my 100 shares that lapses over a 4-year period. So, and it's usually monthly, and it's, on a, after the first year's cliff. So at the end of each year, 25% of my stock has vested. So if I were to leave at the 2-year mark, let's say, 50% of my stock has vested, so 50 shares have already vested. But now Google has a right to buy back 50% of the shares at the value at which they sold it to me, right? So what happens there is that if the value of the shares were, let's say, 1,000 rupees at the day that I was awarded these shares, then at the 2-year mark, they can buy it back at the 500, right? Because that was the value at which they gave it to me. Or it can be the par value of the company or the face value of the company, right? That's a contractual agreement. But essentially, that allows the company to motivate the employee, but at the same time, if they were to leave before the time period that they had agreed to, then they essentially lose the unvested portion of the shares. So it's fair because this is, of course, in addition to your compensation, and that's a commercial discussion. But then you have the opportunity to reward them for their time with the company, and then you take back the unvested shares and give it to somebody else who's going to come in their space, right? So this is a very, very important part of the entire, I would say, the VC ecosystem in many ways, because there's really no other way to sort of make sure the founders are motivated, right? We have a lot of early stage companies that investors are putting large sums of money into, and then the question becomes, how do you make sure that the founders stay committed, and how do you make sure that the team stays committed more than anything else? So if you have any questions about this, I'm happy to take it, but I will talk to you about 83Bs. Again, 83B is a very US-specific requirement. If your shares are subject to vesting, which it will be if you are in a VC ecosystem, then you will need to file something called an 83B the moment you receive your shares, which are subject to vesting, because that will give you the opportunity to not have an adverse tax treatment, right? And the most important thing about your 83B is that there's no penalty for delay, because they do not permit delays. So if you don't file it within 30 days of receiving the stock grant or the restricted stock itself, then you lose the ability to have this tax treatment. So anybody who tells you otherwise is not true. In fact, very recently I had a client who called in and said that, we did this 3 years ago and we forgot to file the 83B, but our lawyer has told us that, we can fix it right now, which is 100% not true, right? The IRS doesn't allow it. In fact, the IRS barely even gives us an acknowledgement when we send an 83B election. So there's no question of, I'll do it later, and, I'll pay a compounding fee, I'll pay a penalty, and I'll get it done. So make sure that if your shares are in a US company and it is subject to vesting, you do file your 83B within 30 days of the stock purchase. Okay? All right, so non-competes and non-solicit. Now, this is something you have to think about as the company grows, of course. The one perspective that I was telling you is, at the early stages, you want to think about what commitments you had to your previous entity and make sure that you're not really running afoul of any of them. But with respect to non-competes and non-solicits with your current employees or with your founders, please look at the applicability of it, right? Non-competes, as you know, are not enforceable in most jurisdictions other than a very, very narrow set of circumstances, both in India and in the US. Right? Non-solicits, on the other hand, have a very different perspective, right? Because non-solicit is not as harshly looked upon as non-competes. So you still have the ability to prevent your, let's say, senior level management from walking away with 10 of your own employees if necessary, right? Provided, of course, you can prove solicitation, but that is something that you should certainly consider, especially with senior level hires that you end up making, right? The other thing that becomes relevant at a slightly more advanced stage is severance. You know, at a senior level hire, a lot of people end up asking for severance because there's a lot of time and effort that goes into it. And just like how we impose vesting, when I say we, I mean the company imposes vesting on the shares, you know, the employee also asks for severance depending on, you know, how complicated or, you know, how advanced the company is at. Okay? All right, then we have stock option plans. Now, ESOPs are one of the best mechanisms that startups have always used to retain employees. And if you look at a typical ESOP pool, we usually see about, you know, I would say 10 to 25%. I know it says 15 there, but, you know, we've also seen 10% option pools. So about 10 to 20% ends up going into the option pool, and the remaining 75 to 80% remains with the founders and the founding team, right? Now, options are really a great way to allow your employees to realize the benefit of the growth in the company's value, right? So they really get some skin in the game. The way options work, in case you're unfamiliar, is that the day the option is granted to you as an employee, and when I say employee, it can also be founders because founders are employees of the company, that's the day on which your strike price is set, right? Or your exercise price is set. Now, if you're in the US, then it has to be at fair market value. The exercise price has to be at fair market value. If you're doing this for an India company, then there's no requirement that the fair market value be applicable to the exercise price or the strike price. So if it's a private limited in India that you're part of, then they will issue it to you at $0, or 0 rupees. But what ends up happening is that at the time that these options have vested and you have the opportunity to exercise it, hopefully the price would have gone up. So as an employee or as a team member, you get to really realize the delta on the increase, right? So you get it at 0 rupees. It's now being sold for 100 rupees because somebody has, you know, offered to buy out the company at that valuation. Then you get to realize that 100 rupees and it comes to you, right? So depending on which jurisdiction you're in, ESOPs are again heavily regulated by the laws of the jurisdiction that you're in. So you can't set up, say, a US company and then use an India ESOP plan and say, hey, it's going to be applicable there, right? Because again, this is a tax construct. There's a big tax aspect to ESOPs itself because it's an option, right? It's like how you trade on the public market. You're essentially buying a put or selling a call, whatever it is. So this is something that you have to be sure you look at. But remember that it's a great retention mechanism. A lot of our startups use it to incentivize employees to stay with the company and feel like they can grow with the company. So very, very effective in terms of what we see. Now, the one thing I do want to point out here is for those of you who are setting up US India or Singapore India or UK India companies, remember that options have a big relevance and they have specifically been mentioned in the ODI regulations of August of 2022. And what I mean by that is that you can issue options so long as the individual is an employee of the subsidiary, right? What we could do before was do something called advisory shares, which actually don't work very well right now, right? So unless this individual is an employee of your company, that is the subsidiary, then you're not going to be able to issue options in the parent company, right? So that, again, is something that is applicable to Indian residents. So make sure that you check on that anytime you're issuing options in a cross-border structure. Okay? So this is what we discussed. You have a company, and you have the employee who gets the options. He gets it at a fixed price, right? So the strike price is determined on the day that it is granted to you. And then after a set number of years, they essentially get to exercise it. Now, that set number of years is the vesting period that we spoke about. Now, many times, what we also do in a lot of our option plans is to say that, if before the exercise there is a change of control or a merger or an acquisition, then we treat those options differently, right? But those are all things that you can discuss with your lawyer anytime you get into this situation. Okay, now the most important thing, I know it says time's up, but can I go on for another 5 minutes? Yes? Okay, thank you very much. I'll try to wrap this up. So we do have the two big financing options that as startups you really need to think about. Are you going to go the debt route or are you going to go the equity route, right? And this obviously warrants a much longer discussion, but I'll try to sort of summarize the high-level issues. See, with respect to debt, the best part of it is that you're not sharing your equity with anybody, right? So there's no ownership. There is absolutely no control, or there's very less control. I won't say no control, but very less control. The downside of it, of a debt, is that you have to repay it at some point of time, depending on what the terms are. And if you don't repay it, you can be forced to liquidate, right? So these are the broad aspects that you have to think about in terms of a debt. Versus with an equity, if you're raising an equity round, you're actually selling off a part of the company, right, at whatever valuation, which means that this individual or this institution now has an opportunity to have a say in potentially how you run the company, has an opportunity to give you suggestions on what needs to be done, strategy that you're looking at, customers that you're looking at, etc. So they're actually a part owner in the company. So that's the biggest thing that you have with equity, right? But the good thing with equity is that there's no payback, right? So nobody's asking you to pay that money back at any point of time. They're really telling you how you're on the same page in that sense, right? Your goals are aligned because both of you want the company to succeed, because both of you will do well if the company succeeds. So the biggest thing that we have with respect to, equity and debt, sort of the biggest difference is the sale of ownership. So if you don't want to sort of give up your ownership and continue to remain in control of the company, then debt might be the best option. If, on the other hand, you would like that help and you would like to bring people into the company, then equity is not a bad option at all. Okay, I think the last one, and this is where my pitch is that you really need to hire good legal counsel. Hopefully, by the end of this session, you've realized that there are a lot of things that can go wrong with respect to not having the right legal team. And I do understand that, for most of our engineers and founders, legal and accounting is sort of an afterthought. And while it's initially that might be something that you're looking at, it might feel like it's very expensive to hire a lawyer, but you should try not hiring a lawyer and see what the cost is much later on, which is not going to be pleasant. So that's really what I have for you. Any questions at all?
Thank you so much. Very helpful, actually. So my question is around advisory shares. So many startups today have a set of advisors, and there's like some sort of an equity goes to them, right? So can you talk a little bit about, is that straightforward? Or is there any best practices or anything that we need to avoid? This is more like I'm bringing in an advisor for my startup who's actually a US citizen based in US. So how does that work, shares for advisors?
Are you a US-India company?
Correct, yeah.
Do you have a Delaware corporation that's set up?
No, not yet. We're very early, but yeah, that's going to be the setup, correct.
Yeah, so I think what I meant when I said advisors and issuing advisory shares is not as straightforward as before is from an India perspective, right?
Okay.
So if you are founders and teams that are sitting in India, and then you have a US company with an India subsidiary or any parent company with an India subsidiary, advisory shares cannot be given out like it used to before, right? If you're doing it via options specifically, you need to be an employee of the subsidiary. Right? So there's no straightforward way to do it. There are a couple of things that we have thought about and sort of, been creative with some of our companies, some of our startups to do that, but that will require some work, right? Because right now the ODI regulations prescribe who can get how many shares and how, right? So it can either go via LRS, it can go via this whole ODI route. Is it going to be, via options? So there are different things that you will have to think about. And these advisors are usually not employees to the company, right? So they are coming in an advisory capacity and sort of, committing to whatever it is that you have agreed to. And that requires a little bit of thought to structure it around them.
So I started my IT services company. I mean, it's not a SaaS company. 3 years back in India, it has its revenue. And 1 year back, I started a US entity in Texas, C Corp. It has its own revenue in US. So since now we are going to acquire more customers, they want to do agreement or MSA in the US, right? So I wanted to understand if I should do a ODI or should I do FDI. So that is something right now I'm working that we are trying to, India entity trying to purchase shares of US entity. Both the companies, I own the shares fully. So what do you suggest, ODI or FDI for, to grow in US?
So you have an India entity and you have a separate US entity.
Yes.
And you want the India to be the parent.
Yeah, I mean, I want to know if India can be a parent or US can be a parent. What is better?
So I think that's a very specific question, so we should probably discuss offline.
Sorry to intervene, but can we just take this conversation offline? Like,
Yes.
we are short of time. Sorry for it. Yeah.
I think that's...
You can always, I think she'll be around here.
Sure.